I am not a lawyer, and nothing in this video or series constitutes legal advice. The information I provide is for general understanding and discussion only. Always consult a qualified attorney for guidance specific to your situation. Hi, this is Michelle from LMA, and this is video 6 of our series on the DTC ban deep dive. This video discusses key legal challenges we're likely to see if the bill passes in whatever form. Number 1, First Amendment, commercial speech protection. The biggest obstacle, pharmaceutical advertising is a form of commercial speech, which is protected, though with lower scrutiny than political speech. Courts require that restrictions on commercial speech meet a test. The restriction must serve a substantial government interest, be narrowly tailored, directly advance the interest, and not be more restrictive than necessary. A blanket ban on truthful, non-misleading DTC advertising would face serious scrutiny. Many commentators and law firms predict that courts will view the law as overbroad, impinging on speech more than necessary. The restrictions sweep, which is all media, all drugs, etc., might fail the narrow tailoring requirement. 2, vagueness, overbreadth doctrines. The statutory definitions, for example, direct-to-consumer advertising, targeting consumers, 30-day look-back, triggering event, may be challenged as vague or overbroad. If advertisers cannot reasonably know whether their communications fall within the ban, courts could find the law unconstitutional for vagueness. The law may sweep in protected or less harmful speech, for example, disease awareness, medically informative but non-promotional communication. And those things should be exempt. Number 3, separation of powers, overreach of FDA authority. Opponents might argue that Congress is delegating too much regulatory discretion, or that the FDA lacks authority to enforce such a sweeping speech restriction without clear enabling language. The law might be challenged as exceeding the FDA's authority or the boundaries of statutory delegation. Number 4, conflict with existing FDA rules and statutory scheme. The bill would amend the misbranding provisions in FD&C, but it must harmonize with existing FDA regulatory framework. Discrepancies or conflicts between the new law and established rules could lead to legal challenges about which provisions prevail and whether certain older rules are displaced. Some argue that the law changes the fundamental balance embedded in FD&C and could be interpreted as contradicting legislative intent. Number 5, equal protection, arbitrary treatment arguments. A challenge might be raised that the law's classification, meaning only approved drugs under certain sections, certain advertisers, within certain time windows, treats similarly situated entities differently in arbitrary ways. For instance, non-manufacturer promotional entities, for example, third-party communications, might escape liability, creating unequal treatment. Number 6, preemption and private rights of action. The bill could face challenges over how it interacts with state laws, whether it preempts conflicting state commercial speech or advertising laws. Questions may also arise whether private entities, for example, patients, third parties, have rights to sue under the new misbranding amendment, and whether courts will recognize implied private rights under the amended statute. Number 7, transitional, grandfathering, and vested rights claims. Those who have existing DTC advertising businesses might argue that the law impairs their vested rights or expectations in their advertising investments. They may seek relief under due process or takings theory, though these arguments are weaker in the speech context. Litigation may target how the law phases in, if at all, and whether it violates retroactive restrictions or due process by abruptly penalizing ongoing campaigns. Let me know what you think in the comments.